Let's get into some XRP news today and talk about the SEC taking another black eye. These guys are taking round after round from the judge, and it's going to be an interesting one for sure. You don't want to miss this show. All right, my name is Paul Barron. Welcome back into Tech Path. Let's get into it. A couple of topics that we'll break down from the judge, but also the kind of impact this could have for the overall crypto markets, even the Coinbase case. We'll give you guys kind of a rundown. One thing I do want to do is thank our sponsor, and that's iTrust Capital. If you guys are looking at going into long-term investing into crypto IRAs, this is one of the vehicles you can use, and it's very simple to do it. Easy to start up. There's no monthly fees, and all you have to do is you can do your own self-directed trading. So if you want to get into XRP or others, you can do that right here within the iTrust Capital IRA. Very easy to join, and you'd be joining another 200,000 accounts that have already created IRAs there with iTrust. So check the link down below. You get a $100 funding reward if you decide to do something there. It helps our channel out. Appreciate that. All right, so let's get into a couple things here. I want to go over to the PDF here. This is the judge response. And there's a few points. I'm going to kind of zoom in on this a little bit for you guys. There's a few spots in here. There's going to be a lot of scrolling, but the point is we're going to get to a couple of points here. I want to go down here to page 5. All right, so let's get into this. First, SEC has not presented a pure question of law. This is one of the things that the judge has already pretty much put in the judgment on the first ruling, and of course, kind of them just saying, hey, this is, you're still in the same position here. In fact, the court specifically rejected defendants' essential ingredients, the legal test, and applied the SEC's legal standards. So this was where the SEC was essentially trying to create their own rules. Judge says, nope, not going to work here. Further into the document, the SEC seeks to appeal question C, an issuer's offers and sales of crypto assets and trading platforms create a reasonable expectation of profits based on the efforts of others. But the court did not hold that offers and sales on a digital asset exchange can create a reasonable expectation of profits based on the efforts of others. So I think that is pretty much the same kind of scenario that's playing out in the Coinbase trial that we will most likely, I think we're going to see a win there as well. Ripple's programmatic sales were blind bid-ask transactions, same as almost every crypto transaction out there. Ripple's programmatic sales represented less than 1% of the global XRP trading volume, did not make any promises or offers, and the SEC failed to provide evidence. The SEC failed to provide evidence, and she just keeps on, failed to provide evidence over and over on all of this. So really kind of hitting home on the SEC just not holding up their end of being able to even prove that XRP or other digital assets are securities. Further in this document, it says the SEC failed to provide evidence and the development of use cases for the XRP ledger, which constitutes a tangible and definable consideration to Ripple. That's important. Court also rejected the SEC's argument that XRP provided Ripple employees as compensation and bonuses satisfies the Howey's first prong. So getting into a lot more detail here, and I think this is going to flow into the rest of the civil cases that are still out there against Garlinghouse and Larson. All right, so court rejects the SEC's remaining argument that the courts have accordingly found Section 5 violations where unregistered crypto asset transactions occur not between the issuer and the investor, but through intermediaries, including on trading platforms. Keyword, on trading platforms. That is Coinbase in a nutshell. And I think that's the scenario. Digital assets, I think, are getting ready to fall outside of the guise of the SEC. Court rejects the argument that there is a substantial ground for difference of opinion, meaning it doesn't matter what you think, the court has a rule of law to go by, and we're going to affect it. And the SEC is not creating their own law, which is the other scenario. Okay, so further in the court, in the document, the court cannot draw any conclusions about LBRY's court reasoning to an issue because it was never litigated. Therefore, the SEC fails to point to any digital asset cases which conflict with the court's holding as to the other distributions. If you don't know about what happened in the LBRY case, this was really a milestone event for the SEC, but now the court is pretty much saying, not really. Listen into this clip right here.
After the blockchain was live. So we didn't do an ICO, and this was during the ICO boom. And even then, we were trying to be a conservative company, and eventually the SEC sued us. And they declined to actually bring the trial until shortly before the statute of limitations was going to hit on our first
buying time.
Yeah. We came in and we did a whole presentation, and they just used that stuff against us, never answered a single one of our questions. We've said we'll destroy the entire company. We'll give you our entire pre-mine. You can have every dollar in our bank accounts, right? But what we want is the status that Bitcoin has, right? If I have to blow everything up, if that's what's somehow the difference here, okay, fine. Just tell me that that's what I have to do. They won't tell you that. They'll say, I mean, seriously, it like gives me an aneurysm.
It's crazy. I mean, that would be the founder of LBRY talking about how much pressure and just gravitas that the SEC is wielding out there on small companies. And that's the problem of overreach that we talk about all the time. All right, so let's go back to, actually, there's another clip I want to play for you. This is John Deaton. Listen to this one.
The judge agreed with me, promised me, assured me that he was going to make sure that the world knew that his decision did not apply to secondary market transactions. And that was a very important point because Judge Torres in the Ripple case cites that hearing. Jeremy Kauffman and LBRY spend between $1 and $4 million, and they spend another couple $1 million in legal fees. The SEC spends ungodly amount of hours, taxpayer money, and when it's all said and done, the government protected us by getting $111,000 from LBRY. Well, we've successfully destroyed them financially. We did what we told Jeremy Kauffman we were going to do when he argued with us, and we said, we will bankrupt you, pal. What happened is the LBRY is appealing the decision by the judge granting summary judgment to the SEC. I think that they have been emboldened, if you will, because of the grayscale ruling, by the Ripple decision, by maybe even the Uniswap decision by Judge Falia, and hopefully a really good decision that comes down in the Coinbase motion to dismiss. Remember, people, there's not a case in 80 years that supports taking an asset that may have been an investment contract in the beginning and then calling it an investment contract, the underlying asset, forever. None.
Yeah, so Deaton pretty passionate about that, and I think he does, kind of hit that point home, is that the SEC kind of plays unfairly. Not surprising to anyone out there, but the good thing is now the courts are starting to rule against them, and this seems like they are finally in a position where they're taking the bully to class. Here, further in the conclusion, denied at the SEC's request for a stay is also denied. So this court basically just lashed everything down. This is an interesting statement at the end. Prior to the final pretrial conference, counsel for both parties, along with parties themselves, shall meet in person for at least 1 hour to discuss the settlement of the matter. So they are really, meaning the court, is really pushing to get this done. This, of course, is Analisa Torres, Judge Analisa Torres, which I think is the one that has pretty much outlined that the SEC has no case here for digital asset control and most likely is going to fall under outside the graces of the court when it comes to the Coinbase case as well. All right, just a couple of tweets here. Corrupt SEC got an F for fail on their appeal. Judge Torres wrote the fail 10 times. Here's Stuart Alderati, of course, the Ripple attorney. Court's July 13 ruling was and remains the law of the land. XRP is not a security. Jeremy Hogan comes in, says, hey, okay, look here. A couple things here that I want to note, and that is really this statement right here. This is a disaster for the agency. I'm going to mark that just so it's there. This is a disaster for the agency, but I think this is a good thing for crypto in general and digital assets, but more importantly, I think for digital asset technology and how all of this is moving forward. Keeping government overreach out of industry and innovation is important. Because as Deaton kind of mentioned, they went through all that, millions and millions and millions of taxpayers' money for $111,000 for a LBRY case, which is probably going to get overturned now. So not a good one. Here was Scott Chamberlain further talking about the XRP case, and he kind of hits something here. It says, law didn't change. SEC failed to prove its case. Now it has to push not something nice uphill with a pointy stick if it wants to win. So they have a huge boulder in front of them to get this done in being able to win. I think the SEC has lost this, and I think it's going to start either looking very bad for Gensler or the SEC is going to start to pivot their position. Now, you look at it politically, that could be the case because we're starting to see some things in DC that could also kind of tie into this. I want to go over to this last clip, which is Deaton talking about this a little bit further into what this might mean. Listen in.
She said some XRP holders no doubt bought XRP for speculative reasons, and they may have relied on the efforts of Ripple, but the SEC didn't prove that. Programmatic sales of XRP on exchanges are not securities. XRP itself is not a security. And what she did in this decision was solidify it. And I'm telling you, it's untouchable. It cannot be touched. She even said, look, I never said that it's impossible for some crypto token to still be a security when it's bought on an exchange. I've just said that XRP in this case with these facts are not, period. She even made it more clear that as of right now, on this day, excluding Bitcoin, XRP is the only one clearly with legal clarity. I'm really hoping that Judge Faria comes through on the Coinbase decision because I think that will be when Gensler is forced to pivot. And that's when Elizabeth Warren has to accept that her anti-crypto army is a bunch of old people about to die.
All right, there you go. Anti-crypto army dead. And I think back to my point is that I think that Gensler is going to pivot. He has to. This is starting to impede political positioning. It's also impeding the benefits of what the SEC is going to try to do in really the work they should be doing, which is real securities law. And that is the challenge, because right now it's just overreach. This is just power grabs. You look at what Graywall was saying here. Of course, this is the Coinbase attorney. SEC just filed its opposition, motion to dismiss their case. This is the opposition to the motion for Coinbase trying to get this dismissed. This is going to take on a light of its own. If you look back down here at the end, it says, we look forward to filing our reply on October 24th. So as always, we appreciate court's consideration. So this is probably going to move into November. But the key here is the SEC continues to lose. And they're losing in very, very grandiose ways. And this is not good for anything from a governmental overreach standpoint. I think it's even worse for the political position of the SEC. And this also starts to change things dramatically, I think, in digital assets as a whole. Most likely Coinbase is going to come out of this. Coinbase is going to look really good pretty soon. So, all right, guys, we're going to get into that more. We're going to be covering more of this. Obviously, we had the Speaker House change up this week. There's a big implication there on crypto and digital assets as a whole. We'll cover that. Make sure and stick around on the channel. If you're not subscribed, make sure and subscribe right now. Just hit that little button down there. If you want to get some of our live streams, we haven't been doing as much lately, but we do want to bring those back. Just hit that bell. You'll get notifications when we do those. All right, if you're not in our Diamond Circle, get in now. It's another place where we drop additional content. We've got a really special surprise for you. We've got new TA videos coming only to our Diamond Circle members twice a week. Those will be dropped on, looks like Monday and Thursday. Plus, you're going to get Kyle's webinar, or excuse me, Web3 podcast, and he's adding another show to it. So you're going to get 4 new pieces of content that you don't get anywhere else, not here on YouTube, only in the Diamond Circle. Click the link down below. You guys want to catch me? It's out there on Twitter, @PaulBaron. We'll catch you next time right here on TechPath.